Good evening, everybody. From Shihab Burke, 6 o'clock Eastern Time. This is when we spend an hour together to talk about a topic of interest and answer your questions. I'm Sam Shihab with the same law firm. And with me,
Brian Burke of Shihab Burke, that very same law firm that you just referenced.
Yeah, exactly.
Yes.
So Shihab Burke, if you guys didn't figure that one out.
Wait a minute. I'm the... sorry.
And just to let everybody know, we are immigration attorneys. We practice immigration law throughout the U.S., from our offices in Dublin, Ohio, and throughout the world. Today we have an interesting topic. Has the Trump-era hardline immigration policies already begun? Because we're starting to see changes.
Interesting things. So I guess I have a list of a couple of items that I have sort of maybe...
So what is the immigration policy hardlines in general? What did we see back in the Trump era before?
I mean, short answer, rare for me, more pushback, more RFVs, harder to get, achieve your goals with the government. Yeah.
Yes.
Yeah.
And also more denials.
Yeah.
More denials, and also things were not as friendly.
Yeah.
The environment was not friendly.
Yeah.
That we had during the Biden administration.
Yeah. Which is still ongoing, and the Trump people have not taken their jobs yet. They can't start until January 20th. Yeah.
But we see. So the question is the answer to the question that we just posed a yes or a no or a maybe?
A maybe leaning towards yes, and you know. So I just said, and 100% accurate, those Trump folks, they don't take effect until January 20th, right? And
there's nothing they can do legally. They're not even on the job.
Yeah, they're not on the job. They can't they can't push the existing people out and say, no, I'm taking care of Homeland Security, you know, USCIS, go away. I'm starting my job early. Not going to happen. You know, these are appointed positions by the executive branch of the United States, presently controlled by Joseph R. Biden, president for another month or so. And fine.
However.
Yes.
There's a however.
Yeah, let's maybe sort of talk about the stratification of the agencies. At the top, they're the people who get, you know, appointed, right? And then there's everybody else. And it's not hard to imagine that everybody else knows that there is the non-political appointees, the people who are going to be there, whoever is the boss, right? People who know that the winds are changing, and you know, are they maybe getting ahead of the game to, you know, to carry favor with the people coming in, to basically get the agenda rolling, to please their incoming overlords, more or less, right?
So we know who is the upcoming USCIS, and
what's the lady from whose name is absolutely escaping me? Well, the Homeland Security is Kristi Noem.
Yeah, but it's not. It's not that critical, except that the people on top at the Biden administration are looking for jobs.
Yeah, yeah.
They probably are not really now engaged in the day-to-day running of USCIS. They are engaged in the day-to-day running of
getting myself a nice, cushy job in the private sector.
Where is my next job? Because I'm leaving.
Yeah.
I'm calling my friends.
Yeah.
To see if they have opportunities for me in law firms, in other
law firm,
agencies.
Consulting, lobbying, yeah, yeah.
You know, those guys, that's basically, it's a revolving door. When the Democrats comes back, they bring them back on the job.
Yeah. All their friends at the consulting company, they're going to join her to say, hey, welcome back, and they'll say goodbye to them when the next administration comes in and, you know, takes somebody from them. Yeah.
Yeah. So these guys are not paying attention, and now we are seeing in our office different types of RFEs.
Yeah.
And different frequency of RFEs.
Yeah, I mean, so to be clear, there's people at the top, if they've got their eyes closed, their minds elsewhere. The people at the bottom, they do have their minds on immigration. Maybe they're saying, well, maybe they're making some decisions that they might normally make in the past, or maybe they just don't have the thorough supervision of the political folks, and why do they care? And that doesn't sound so crazy to me. And we were just sort of talking about what we're going to talk about today, and you know, we just sort of in our conversation, just noted a couple things that seemed unusual from what the trends have been recently.
So we have a notice of intent to deny. It looks like they're happy notice of intent to deny. We're getting more of those in the last 2 months I've seen than in the last 6 or 8 or 9 months.
Yeah, somebody doing some H-1B cat cases that we know has basically gotten,
more than one client that we're seeing notice of intent to deny being fired on them for stuff that are silly.
Yeah.
Not exactly.
Well, I'll tell you one I had recently. I will omit the details, and nothing reflects poorly upon our client anyway. But basically, there's a notice of intent to revoke on an I-140 petition, right? And it basically says, "Hey, we think you engaged in fraud." Now, what it actually said was that what happened was the I-140 beneficiary and their prior employer allegedly had been involved in some sort of immigration fraud scheme. But they sent me a notice of intent to revoke on our client's I-140 saying, you engaged in fraud, despite the fact, that it is clear the fraud was upon somebody else and their employee, and how could they have known of it? Just little things like that. Just sort of, why are you accusing us of
happy trigger?
Yeah, happy trigger. Now, I'm going to pat myself on the head. I sent them a screamer of a response saying, it's pretty darn obvious here who the fraud is, and basically
alleged fraud.
Yeah, alleged fraud. You're alleging fraud as to this person, a fraud that you couldn't even figure out at the time. And how the hell were we supposed to have caught it? Very fun. I've been having really good results on noirs recently, Sam. And this is another one where I got them to come to me tail between the legs saying, sorry, we didn't mean to suggest your client had engaged in fraud or misrepresentation. Well, why did you write literally petition or fraud or misrepresentation all over this? Very upsetting, but trigger happy.
Because
nobody reads them.
Template.
Yeah.
They have they went back to the old templates of RFEs, not the new templates that the Biden administration had them use.
Yeah.
So they went back into their old template folder, clicked on that, and they start using that in their RFEs. On
a sort of related note, I have an I-140 RFE on my desk of a certain type that I haven't seen that type in like about a year. Sometimes they ask about, it's an issue relating to experience gained with the same employer, and I haven't gotten that question for at least a year. I'm not too worried about it. I know how to respond to that RFE. I've done them before, but I haven't seen them. During the prior administration, we were seeing them a lot more.
And it's not like this administration is telling people to change, because the leaders, I'll be shocked if they're showing up to their work and putting in 40 hours a week right now. I think those guys are not in the business of changing policy. Or
why should I set policy if the incoming folks are going to toss it out anyway, Yeah.
So there's none of that going on. So we think that officers are not closely being watched anymore, and because of that, some of them who maybe did not like the fact that there was a easier review process are reverting back to their method of comfort zone.
The people who were put in the corner, more or less, by the current administration leadership, the friendly folks, are saying,
revolting.
"I'm back, baby. I'm the sage wisdom, the seasoned professional that the people who are coming in are going to want to say, I want to talk to the guy who's denying cases. He's my hero,
Right. Yeah. So Do you see? We also see. I don't know if that is something that is enough that I can say that there's more pushback on litigation.
So raise your hand if you just got a motion attempt to dismiss a mandamus action today from a U.S. attorney. And when we talk about doing a mandamus action with a client, we always warn them it's possible that the government's going to fight with us. But this will be the second motion to dismiss on a mandamus action of sympathetic facts. People have been waiting for visas for a long time.
Yeah, it's one of the cases, unrelated. But the funny thing is, once they got our slam dunk response, was there was a change of tune, because by the time they read the response that we've drafted for their mandamus, it looks like the government saying, "Oh, this is very sympathetic. The judge can slam us for an order to make a decision," and we saw a positive cooperation.
It's very funny. I mean, I tried to call our client today and just, she's waiting. I told her the hope on the case like this is before we never get to the point where they move to dismiss or file an answer. They just say, hey guys, we'll give us some time. We'll look into this and we'll extend this. But instead of getting that on this case, I get a motion to dismiss. But even in this case, the same thing there. She's seeing, all I heard from the government was motion to dismiss, but she's seeing updates on her husband's, visa application
So even though they're filing
online.
the motion to dismiss, if the case is moving.
Yeah,
So
maybe they're just changing it to move the cases. Let's not keep them on the docket.
Yeah. I mean, obviously, but now I'm seeing improve. I mean, the other one, because I think there was an attitude first. I'm seeing the communication.
Yeah.
There was an attitude first.
How dare you, essentially?
No, we're gonna we've gotten the go ahead from the State Department to fight this case.
We're going to be, I remember, we're going to be dismissing
because
it.
of this, and that, and then they filed it, and then they got the response from us, and now they're saying, did the client provide all the information? They want this case to be approved before the judge.
Oh yeah, I mean, I know the facts.
Before the judge rules.
I know the facts of this case, and I had a couple of 4-letter words for them, thinking they could dismiss it on the grounds that they made up.
I don't know. So do you think that's a Trumpanian or a trumpet?
Well,
or
I mean,
what is that? Do you think that's
everybody's a human being, and the U.S. attorneys all around the country, they report to the Attorney General. There are people who are politically appointed, the Attorney General, and there are Assistant Attorney Generals who are not, politically. I guess any of them can be replaced. Like the one out of New York, for example, is probably going to be replaced because he was prosecuting Donald Trump, for example. Yeah. But basically, those guys aren't dumb. They know where the political tides are going. They know what the priorities of the incoming administration are going to be. If you want to keep your job, because those guys can be fired. I don't blame them for it. It's you act upon what you expect. I mean, literally, the guy who was. Decisions right now. If you want to talk about the broader political things, there were federal court cases against Donald Trump for a couple of things. I won't go into the details. And that guy said, "Hey, let's cancel these cases." Even though the Biden administration isn't over, they said, "Let's close down these cases because we know they're not going anywhere and they're not getting resolved in the next 60 days."
So do we see increased scrutiny on family-based cases?
Family-based cases?
Hard to tell, in my opinion. I know there has been. We practice in multiple jurisdictions.
I have an example of this, but finish your thought.
We practice multiple jurisdictions, and some jurisdiction. I'm not going to mention certain name of jurisdiction here in the conversation. In some jurisdiction, there is a little bit more of a civilized culture.
Yeah.
Some other jurisdiction, there is less civilized culture. There's no question.
Yeah.
Some of the big city places, sometimes you go there and you see officers who are busy and competent.
Oh yeah.
And they want to move things along. They've seen a lot of cases. They've seen tons of cases. They know what's a good case, what's a bad case. Then we go to some big city also, jurisdiction, where it is basically stuck in 1965.
Yeah.
Where they basically have these old people who take pride in handing out denials, and they don't give a damn.
Yeah, I mean, as an aside, the folks in Columbus are absolutely super.
No, we're not mentioning anybody.
Well,
but Columbus is very good.
Oh my God, everybody in Columbus, the officers in my experience, are super nice, super professional, and treat everybody with respect. But yeah, I mean, yeah, there are.
We practice all throughout the U.S.
Yeah, I've traveled. Raise your hand if you've traveled across the United States this year for a green card interview. Yeah, right. Fun, yeah.
Yeah. So we see it all, and yeah, we see different. But I think it's a function. The reason I'm saying that is because I don't think it's a function of a changed culture because of the change in administration. I think it's just a function of the office you're in.
This is true. Anecdotally, I was downtown here in Columbus, maybe beginning of November for a naturalization interview. I told you about this one where he had an issue where if they wanted to be really mean to him, they could have essentially put him in removal proceedings. Technically, he would be eligible. And I said at the end of it, officer, just, I know the political winds are changing, and we would appreciate a decision on this matter as soon as possible. And she said, don't worry about it. Don't worry about it. I'll have you guys taken care of by the end of the week. And literally, she was right.
Do you think there's longer delays?
I don't think I'm seeing anything along those lines yet. I mean, that's my number one worry though going forward. I mean, I think RFEs and more scrutiny. They can.
What about the increase in denials?
Not yet. I touch wood.
We haven't seen them.
Yeah.
We haven't seen denials.
Yeah.
We've been very lucky. Okay. So, but do you think nastier noirs, RFEs, clearly more scrutiny, and maybe pushback in litigation a little bit?
Yeah.
So we see a change, and I think it's more of the leash has been cut off. So it is not I think people are now doing what they want to do rather than what this administration wants them to do.
I think that's a reasonable interpretation of it. Basically, I'm going to make whatever decisions I want as an officer, and I'm not going to have to worry about the neck of the people, the boot of the person at the top on my neck because they're going bye-bye. I think it can be easily interpreted as to I'm anticipating, I want the warm embrace of my new political leadership, and thereby I'm going to get on the train a little bit early and be in class a little bit early with a little apple on the teacher's desk for them.
So that's what's happening. That's a good summary. So ultimately, for us, it doesn't make a difference. I mean, our cases. I mean, honestly, I would love cases that are simpler and easier, but we are in the class of law firms who are very experienced and very organized and have a track record of great success. We don't have a problem when things get more tougher. As a matter of fact, unfortunately, advantage firms like us because when things are difficult, we are the more competent firms that can handle it. But we would like things to be easier.
Yeah, no, I told the lady I talked to today about the motion to dismiss. It's we knew this was a possibility. It's just I would love it if she sounded disappointed, and she rightfully so. I said, you know what, it's my job to respond to these things. This is what we hope for, but this is just. It wasn't what you hoped for, but it's just part of the process, and I get the fun of writing a comparable response to a 30-some page motion to dismiss.
Yes, nice. Yeah. Sounds good. We will take what they throw at us. We're always prepared, anyways. It doesn't bother us.
It's what we do. It's specifically what our job is.
But definitely, we see a change.
Yeah.
Would that be that would be a good conclusion?
We sort of had that. It doesn't sound crazy to me, and yeah.
All right, sounds good. So we switch gears.
Yeah.
And if you take that screen up higher and bring it down, Brian.
I'm going to do some tradesy flopsies on our monitors here so everybody can see our questions.
Yeah.
So.
All right, wonderful. So this is the time when we will take questions and answer your questions. And just remember, because we're answering questions doesn't mean that we've established an attorney-client relationship. We'd love to establish an attorney-client relationship with you if you're not a client already, except that it is not through this medium, because this medium is to give you a short answer to a short questions, to give you some guidelines to help you out. If you believe that anything we've said struck an interest for you, consult an attorney of your choice. Before you make a decision on your case, you owe it to yourself, because obviously we don't know enough about your case to give you a comprehensive review. Be that as it may, let's take the first one, Brian.
Yes.
Without delay.
From RB, I got my first CAP H-1B stamp in July 2023. I never joined the employer or worked for that employer starting October 1st. Can I use this H-1B visa petition approval to file with another employer? So, the short answer in that one is, I guess the very short answer, this is probably what I tell any employer who asks me this question. Probably yes. Policy is wishy-washy. We haven't really seen pushback for it until like maybe the last year or so, where we've seen a couple questions on the subject. And that's maybe my starting answer there. Sam, what are your thoughts?
Okay, so obviously there's a couple things here. And this is an excellent question. And just to let everybody know, we try to answer the question and then answer a little bit more around it to maybe make sure that maybe we're answering more than one question if people have similar questions. So, so there's a couple of things going on here. The first thing is because there is a stamp on the passport, that H-1B has counted against the cap.
Yeah, if you read the regulations, so this is a fundamental question of when am I counted against the H-1B cap, right? And as we've read the regulations, or maybe it's in the law in the past, it's basically when are you counted against the H-1B cap? When you've gotten a visa stamp or you've been given an I-94 and actually been on H-1B status in the United States. Fine, and that's
the first piece.
Yeah.
The second piece is, let's assume he applied for an H-1B with another employer, gets approved, get a I-797 with consular notification. Obviously, he is outside the U.S. in our assumption. Now, that stamp on his passport that he got that has the other employer's name on it, can he use it to fly to the U.S.?
Oh, yeah. And sorry, I wasn't even picking up that question, but yes. So you're talking about, I've gotten that visa stamp, but can I use a petition approval with another employer and that visa stamp to come to the United States? Sure. Yeah.
Excellent. Okay, fantastic. So those are the two things that came to my mind with that question. This is an excellent question. So hopefully we now I have a follow-up on that before we leave it to the next question. Do you think a change in the administration can change any of these answers that we've just given?
Yes. I think so. If an employer asked me, they said, I have this guy, RB, he has an H-1B approval from another company and he got a visa stamp. Can I file an H-1B for him and bring him to the United States through my company? I would say yes. Policy is reasonably clear that if you get a stamp, you're counted under the cap. But I have seen cases where they question that.
I thought it's not policy. I thought it's regulations.
It is regulation, but I've seen them say, well, technically speaking, you're not counted unless you actually use that visa stamp to enter. We fought that one. I'm pretty sure we won that one. So there is.
There's an opportunity to fight it, but I would say. I would give it a little bit different answer than yours. I would say I think the answer holds with the new administration, but don't be surprised if there's a pushback. But it should hold.
Most employers I talk to, they usually take the risk and go through with the H-1B filing because we've seen good results.
All right, fantastic. So good. Let's take the next one.
Okay.
All right. So Ignacio Mali, if you change jobs while the I-485 is pending, assuming 180 days have passed since the application is received, would that pose a problem when filing for naturalization? Do you also need an I-140 approved? So here are the facts of the case as I understand it.
Okay.
This gentleman had an I-485 pending and changed employer after 180 days. And then many years later, after he got his green card, now he's applying for naturalization, or he's asking, maybe it's not happening, he's looking forward and saying, if I apply for naturalization 5 years from now after I get, or when I get my green card, or after I get my green card, would changing job within 180 days affect my naturalization? So that's the question, as I understand it.
I think I'm going to be answering a different question. So here's...
Okay. So what's the question you're answering?
So for my answer to this question is, it could be, what I think it might be is this, is I'm going to presume this person has filed I-140 and I-45 simultaneously, right? And if I change jobs and my I-45 has been pending for 180 days, but my I-140 has not yet been approved, can that be a problem? Here's the question there is, do you also need an I-140 approved? So
that's kind of part B, I was thinking, because to me, one is yes, one is no.
Well,
to me, but that's why I kind of split them. So those are two separate questions in my opinion. So we'll answer the first one for you.
Okay.
If the I-140, okay, if you change up within 180 days, after 180 days, but the I-140 was still pending. And then what happens?
They should issue an RFE on the I-140, basically giving the employer an option to keep it alive, despite the fact that you've left. And the problem is well, go ahead, finish that.
No, continue.
And the bottom line is, if that I-140 is not approved, I mean, to answer, do you need an I-140 to get an approved I-45? Employment-based, yes. And if that I-140 is never approved, you're not getting that green card. You're never getting to naturalization.
Well, okay. So, so the I-140 was pending.
Yep.
I-140 was pending. more than 180 days.
Yep.
Wasn't approved. I-45 was pending for more than 180 days.
Under which policy you're able to change jobs. Yep.
He changed his jobs
Yep.
without the I-140 being approved.
Yep.
4 months after he did that, or she did that,
Yeah.
the I-140 got approved.
Okay. Sure.
5 years forward, any problem with naturalization?
No.
All right, so people are clear on. So I'm clarifying.
Well,
so,
you've given a scenario where the I-140 is approved. I'm just going gloom and doom for denial.
well, yeah, because he didn't say denial here.
He said, do you need your I-140 approved? And the answer is yes.
Well, yeah, but he didn't say it's denial.
Okay.
But so we're answering the question.
yeah.
So we're answering the question. So if you change jobs while the I-45 is pending, more than 180 days,
Yep.
and the I-140 was still pending,
Yeah.
you are at risk.
Yeah.
You are at risk. It is not recommended that you do that. Now, if you did that, and later on the I-140 is approved,
Great.
and then later on the green card is approved, I don't see a problem with for the naturalization. However, do not assume that we're telling you you should do that.
Yeah.
You should always change job after the I-140 is approved and after 180 days pass on the I-485.
Yeah.
Never change job before that. And if that happens, under both scenarios, 5 years later, and if the I-140 is approved and the green card is issued, there's no problem with naturalization.
Yeah. Bottom line, unless they find something egregious while processing your naturalization application, don't really expect they've gone back and really kind of deeply analyzed your green card application or how you got your green card. Yeah. Today, you're right. Today. Yeah.
So today,
Yeah.
because what we will have in the future can be a completely different ballgame.
Sure. Yeah.
And therefore, you want to do things right. I'm not even in the future, even under the most restrictive analysis, Brian.
Yeah.
See if you agree with me. If the I-140 was pending and he changed jobs, and then subsequently was approved.
Yep.
And the I-45 subsequently was approved.
Yep.
And the green card naturalization interview 5 years later. I know it's not happening today. Do you foresee a scenario which USCIS would say, you left the company, it appears to us that there was not a bona fide offer of employment and that green card should not have been approved? Do you foresee that?
It doesn't seem high. It seems
Low chance.
Yeah.
Extremely low chance.
Yeah. That's the bottom line.
I agree. Yeah. All right. Sounds good. So I hope we can answer the questions around it.
Yeah. So I'm going to take this one from Saif Khan. My I-140 is approved. Congratulations. Can I change my employer for better opportunity before 180 days? Can my current employer revoke my application? So short answer is yes. If your I-140 is approved for less than 180 days, your employer can send a withdrawal. If they get it to USCIS within 180 days, your I-140 approval is withdrawn, and all you keep is the priority date.
What does he keep beyond 180 days?
Beyond 180 days, we have a great video about this, all the about changes of job when your green card's in process. But if you beyond 180 days and your employer attempts to withdraw it, USCIS will basically sort of acknowledge the employer's revocation of the job offer, but they leave the I-140 approved, meaning that I-140 is available to you to extend your H-1B beyond 6 years or give your spouse the benefit of an H-4 EAD.
Okay.
Yeah.
And that's really nice.
Very nice, yeah.
So giving up a job before 180 days might not be a smart thing to do.
If I were talking, I've talked to people about this scenario. It's basically, it's not in your best interest to leave within 180 days of an I-140 approval because they will have every motivation to withdraw your I-140. If they're irritated with you and aware of the law, they can say, well, screw him. I'm going to withdraw his I-140. And
Safe
how
has
dare
a
you?
follow-up for you.
Safe, yes. I'm going to trust your pronunciation on that. Safe says, I am eligible to file I-45 with EAD and advance parole. If EAD is approved, can I change my employer before 180 days of I-140? It seems like answering questions thoroughly, like on the last one, that provide useful results for this answer. So the rules for changing of employer is once your I-485 has been pending for more than 180 days, yes, you are allowed to change your employer, even if your I-140 is not approved yet. But I'm going to quote Sam of a couple minutes ago. Oh boy, we don't recommend that because it's just not a good idea because you're putting at risk that I-140, which you need to have to get a green card.
We have a video about all these nuances.
Yeah.
So if the I-140 is approved but less than 180 days
Yeah.
of
Yeah.
the I-140 approval, and
Yeah.
then the I-45 cannot be pending more than 180
Yeah,
days,
yeah.
logically,
Yeah.
and you change job before 180 days and the I-140 is withdrawn, that can destroy your I-45.
Yeah.
Whereas if you waited,
Oh yeah, yeah. So yeah, sorry. Yeah, I never. Yeah, never before 180 days of
180 days of I-140.
Yeah,
so,
you have-
so that
yeah.
so that is a terrible thing to do.
Yeah.
To change employer before 180 days of I-140.
Yeah.
But you could, after 180 days of I-140, potentially, and,
At that point-
and ideally beyond 180 days of the I-45.
Well, you have to be wait 180 days of the 180 days of the I-45.
I-45 in any scenario, yes.
Yeah. But there could be a scenario where your I-45 is pending 180 days and your I-140 is approved, but pending less than 100, but approved for less than 180 days, where you could still leave and continue your green card. We have a really good video about that where we spent.
We have 3 series.
It's called change. Look at our videos, but it's called this. They're about change of employer with green card and processes. What it's
With green card and process, we probably broke down 10 or 15 scenarios. I think we believe.
Yeah.
We believe now. That is not proven by any means that USCIS took our chart.
Oh yeah, and put it on that.
And modified it, improved it, maybe, or expanded it and put it on their website.
Yeah.
But that's our belief.
I'm having terrible flashbacks. We spent hours like perfecting our charts as the best way to represent these things for those presentations.
Very difficult scenario.
Yeah.
So we have, as a matter of fact, I've had teachers, professors contacting me about that chart.
Wanting to fight it with us about it. Yeah.
No, not clear on some issues, which I've clarified to them, and they shared it with their students in classes and so forth.
Yeah.
So
it's a good resource. Sometimes I'm looking for an answer. I get that chart when I Google.
Yeah, the chart is on our website.
Yeah.
And the videos are on our YouTube.
Yeah.
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 But those are good stuff. Yeah.
Yes. Bam. From Sunny.
My husband has an approved I-140 in EB1 category, in which one of the criteria he used is evidence of your performance in a leading critical role in a distinguished organization. All right.
Uh-huh.
In such case, can he change employer?
Sorry.
Yeah, so has an approved I-140. So that I-140 is approved.
Yeah, but it sounds to me like this is an EB1 A I-140, which is self-sponsored, meaning that I-140 belongs, assuming it's an EB1 A I-140, it's an extraordinary ability I-140, which means it's not something any employer sponsored your husband for. It's basically he self-sponsored himself, meaning he can change. He should be able to change.
The worry that Sunny has.
Yeah.
She is concerned because let's assume he's working for Microsoft, distinguished organization, and he was doing a leading role for a distinguished organization.
Yeah.
Now he joins a startup.
Yeah.
And now that
puny company, no reputation.
Yes. Is that a problem?
I-140 is approved. You don't have to have to meet that criteria for an I-140 approval. You don't have to be working in that distinguished organization right now. For example, I was putting in the office over the weekend, putting together an EB1A I-140, making argument for distinguished organizations. I'm arguing based upon this lady's current employer, as well as the one she was working for prior. So again, what that is that working for a distinguished organization is evidence that you're extraordinary, essentially. And just because you don't have to be working there.
I wouldn't worry about the I-140 being. There's no. I'm not worried about that. Again, I don't think that's a concern in the future. We're going to turn into a different administration. I don't think that has ever been an issue in a scenario like this, ever.
Yeah.
You've gotten the I-140 approved. Clearly, he did work for a distinguished organization. He is not required to permanently work in a distinguished role in a critical role in a distinguished organization forever. That's not a requirement. Has worked is sufficient.
Yeah, I mean, thinking about it, Sonny, if I'm doing an EB-1A application, and I am right now, there are like 8 criteria you could potentially meet. And I'm going to argue, all 8 of them if I can. Basically, there's a reasonable chance that, you don't ever know because the I-140 is approved, and who cares at this point, but you will never know what criteria they actually approved the case on. They could have thought, his organization wasn't distinguished, but they still chose to approve the case because he met other criteria, Yeah,
I agree.
Yeah. So, going to keep it going. I think we already took that one from Safe. Yep. So we're going to go down to MG here.
With the release of the January...
Sorry, pop up.
Yeah, with the release of the January bulletin, we see no change for EB1 India yet again. With the rest of the world staying current all these months, why are the dates not progressing at all, despite spillover? Well, as we look up these dates, Brian's doing that right now, we can only give you a speculation. We don't have the access to the numbers.
Sam, I looked at earlier, when thinking about a YouTube topic, I looked, and the visa bulletin wasn't there circa like noon today. Annoying, but
So, complete speculation. If there is enough EB1 approved for people with older priority date from India, these will come ahead and force that visa bulletin date not move forward.
Yeah.
So that is really the only.
Yeah. I think I'm on the same page as you. It's basically, well, we already have enough. Why I can't move these numbers forward any further? We already have enough people to take care of the visas we have. Use the visas we have right now.
So if they had 400 cases for India that they can move from rest of the world, let's assume this. I haven't looked at one third of 28%. 28%. I'm not going to do calculation, but 1/3. 28% of 140,000, Brian, divided by 4, whatever that number ends up being, and then we can just say there was 500 cases that could be spilled over to India.
Yeah.
But there is 510 cases that were approved from older priority days. That will make the number not move forward whatsoever.
So I'm looking at the visa bulletin here, Sam. It seems that one of the big interesting questions for us was, hey, are we going to see any movement on the rest of the world? Oh, so on the dates for filing, because if the dates for filing move, that would indicate that that would bode well for a lot of people who are wondering whether, what do the dates for filing mean right now? Do they mean something where they're going to across the are they just going to come together across? Do dates for filing and final action dates just come together across the or
as of October, and end of the fiscal year. So what have you moved? Have you seen any movements?
I'm just forgive our neck craning, but we see it on the monitor above our monitor here. But basically, this is December 2024 dates for filing, right? And here we are, January 2025. I've been comparing back and forth. They appear to be identical. January 23, 15 April 2022, same. August, October, January, August.
So this is consistent with what we're thinking.
Yeah.
Okay. So that's really the only answer that we can give MG with the release of the January visa bulletin. Why don't we see EB1 India moving, even though there is more visas available? Yeah. Unfortunately, that's probably the most likely answer.
Yeah. Yeah.
All right. So next one, Brian. All right, go ahead, Brian.
Do you think employees-based visa move faster as a family-based visa would have more securitization? So
he's talking about with the new Trump administration.
Yeah.
Do you think?
So all we can go is based upon what we knew would have happened last time, right? And I would say boy howdy, they were putting the scrutiny on employment, immigration, especially H-1B visas.
But not green cards.
Not really, yeah. No, well, a little bit green cards. We had the public charge rule that was basically, designed to make it a little bit more painful.
But honestly, that public charge rule was really aimed at
Family.
family, let's face it. But obviously, we got collateral damage.
Yeah. I'm still traumatized by that form. But in terms of what we were seeing in family immigration, the I-130s, I-45s we were filing in the United States, I don't really remember, feeling hurt on those. Where I was feeling the pinch was consular processing of family-based immigration. They basically starved the Department of State. They put a hiring freeze on there, and people left because they weren't happy with the incoming administration, and it slowed things down like crazy. And that impacted, both family-based and employment-based at the consulate, because it's consulate operating on skeleton staff. Compounding that with COVID, the family did get really, really hurt because they gave away family visas to the employment-based green cards. So
the answer is yes. We believe that we will experience improvement in the employment-based cases because of the slowing down that we will anticipate in the family immigration case.
Yeah, if they are slower to approve cases of the consulates, and let's say hypothetically, they don't even take a nice mandamus action that some attorneys worked really hard on and was really hoping to get a good.
Not every applicant is going to file a lawsuit.
Yeah, this is true.
Yeah.
But I mean, if they slow things down at the consulate, and certain places in the world, boy howdy, they are slow at the consulates, and if they get slower, that's, in theory, less visas issued and more rollover. I mean, I'm still intrigued. I don't know if they ever updated the employment-based adjustment of status FAQs, where they said, hey, based adjustment of status FAQs, where they said, hey, we're going to actually have more visas than we thought, this year. And again, on the FAQ page, it says the employment-based annual limit for fiscal year 2025 will be higher than was typically before the pandemic, but lower than fiscal year 21 through 2024. So, they haven't updated this anytime recently, but that's essentially what's at play here, I guess.
Yep.
Yeah. Well.
All right. Sophia Ivy.
Yeah.
Can you talk about the visa bulletin for January 2025? I filed my I-45 using the filing date in November of 2024. The filing date retrogressed. What does it mean if you filed it when it was current prior to the date May 30th, 23?
Well,
so
there's some sort of change, obviously.
It would be nice to know what Sophie filed it for, what type: family immigration, employment immigration.
That's a great point.
But something retrogressed. And then what category? So if Sophie can share that with us, maybe we'll postpone that for a few minutes and see if we can pick up Sophie's comments.
Yeah, because I'm looking at the employment, and I have them next to each other now.
Trying to
They're
guess.
looking identical to me in terms of dates for filing. That's for sure.
So
maybe it's a family one. Yeah.
So go to the bottom, see if Sophie gave us his details right now.
Another question, the same.
No.
Well, Sophie will come. Maybe
we'll come back to Sophie here.
There's another question from Sophie in the list anyway. So yeah.
Okay.
Yeah. Well, I guess there's a general question. If a priority date retrogresses, if you file an I-45, Sam, and then the priority date retrogresses, your I-45 just gets essentially put on the shelf until your visa is available. Right?
Well, there's a lot of implications.
Yeah.
So she filed on the filing dates.
Yep.
Not final action date.
Yep.
And then it retrogressed. So if Sophie has dependents,
yep.
There is implication under the Child Status Protection Act.
Sure.
That are very critical. Also, there is implication on her work authorization. If she has an EAD under adjustment status, she will continue to receive employment authorization in the U.S., and her dependents will receive employment authorization and advanced parole until such time the green card is issued, which could be 1 year, 2 years, 6 months, 5 years, 8 years, who knows. With regard to the Child Status Protection Act implication, that's an interesting question and a complicated one that requires a little bit more paying attention to the specifics.
You just invented a child that we don't know exists yet.
Yeah, but there is, you get some benefit and some credit of that retrogression.
Yeah, your date's not available.
But you have to be careful looking at it. But obviously they've moved the Child Status Protection Act freeze to the filing date. So that's great news that you file under the Child Status Protection Act. The question is when visa is unavailable, what happens?
Yeah.
And that we need to kind of look at carefully in answering the question. So we're answering the question in a very general format. Hopefully that we've given Sophie some direction. If she gave us what category and what...
well, we have an answer from Sophie down here that says, sorry for the confusion, I was wrong, so maybe her date has not retrogressed. It's just...
Okay, Well, good question anyways. You created a good question, Sophie.
We like talking, and you gave us something to talk about. That's for sure.
Yep. All right, sounds good.
So let's see here. Let me see. I think Sophie asked her question twice, so here we are. That's the first one. So from Huri. Yes.
All right. Do you believe Trump will help DACA recipients? As a matter of fact, he said something.
He was open to a negotiation on that subject.
I guess everything for him is negotiation. Negotiation what? This is people's livelihood.
It always makes him fun to talk about though, because everything is a negotiation.
What negotiation? I mean, but yes, I think he's open. He has to be open. If he needs to solve the problem, he has to accept facts.
Yeah. Well, my take is if he thinks he can deport everybody who's here illegally, he's going to eventually need money. He's going to eventually need
he needs resources.
Resources, yes.
It's not possible. The conversation is a joke.
Yeah.
The discussion is a joke. Anybody that takes Trump seriously on his statements that he's going to deport, I mean, is it going to be the largest deportation ever in the history of this country? Possibly. I'm not gonna say it will not be, but is he going to deport everybody? Absolutely not. Not possible, especially DACA, because these people have jobs, they have work authorization.
They don't. His prior administration though came after DACA, and I think it's reasonable to believe that they will come after it again. It survived. I think it's still being litigated in court.
But in the priority list, it is not high on priority.
No.
And he's already said
criminals first. Yeah.
People with order of deportation.
Yeah.
People with criminal background.
Yeah.
Then people illegal, securing the border, not increasing the number.
Yep.
Then people on TPS, it's a big deal for him. It's a big number, which is going to be a problem for him. A lot of people have work authorization working. There's going to be a big impact. Yeah. And then people who are illegal, and then DACA. Yeah. By the time you get to DACA, Trump will be 120 years old. Yeah, I know. And it will be his 7th term as the president of the United States.
Don't say things like that.
If you leave it up to him.
Yeah, I mean, one of the things I think about is the TPS designation periods. If I don't know, I've never really looked into the law as to when they can designate them, but how long to designate it for.
They're renewed one or 2 years.
Yeah, I mean, I'm just looking for looks like Syria is extended through September 30th, 2025, and
that will not be renewed, by the way. I don't know if you're following the news.
I followed that a little bit.
Weekend. Yeah, a major event in Syria. The dictator al-Assad was toppled.
Yeah, 50 years of family dictatorship, right?
In a fantastic way.
Yeah.
In 4 days.
Yeah.
They were.
That news story caught me on guard. I heard like rumblings of something.
Yeah, I was obviously. I'm originally from Syria, so everybody knows my father is from Damascus. I lived 3 years there and I lived in other parts of the country. So I was watching it. I have one uncle left in Damascus. Yeah. All my and a lot of cousins, first cousins that I've lost touch with. Yeah. I've been here for 4 years in the U.S. But yeah, I was watching it. It's spectacular news, crazy news. But obviously, we need to see what's going to happen next. But TPS for Syria probably not going to be renewed. Asylum for Syria, by the way, in France is froze overnight. Yeah. Germany froze. Europe has announced freezing, and then there is an influx. This civil war in Syria displaced 50% of the population, which is about 14 million individuals. Mm-hmm. So there's going to be an influx of 10 million people.
Well, I mean, I was already reading stories of people already coming back to Syria from neighboring countries.
Yeah, they can't stop. I mean, and then they've opened the jails.
Yeah.
That was a massive thing.
Political.
And there are some videos. Yeah. I mean,
I was watching. I was Sunday morning, right?
They released a 4-year-old child.
Yeah.
A 4-year-old child in jail. So, wow, right?
Wow.
But digressing.
Yeah.
Back to TPS. So his priorities are not DACA to go after. 100%. He loves the deal. Trump would go to McDonald's and he would say, "Give me."
I believe he would go to McDonald's. Yes.
2 extra fries for me. Doing something, or he loves the deal. So
it is the most fun part about him. Nothing's really off the table, and I legitimately believe if he thought he could achieve his goals, by making a deal on DACA, that he would. And I believe he's genuine in that too.
Yeah. So I mean, I learned something a long time ago in negotiations. This is one of the best lessons I've learned about negotiations. Is if you want to give this to the other person, don't give it unless you get something in return. Why? Because once you get something in return, even the something in return you don't want, now this thing you're giving becomes valuable. Yeah. You just created value in the thing you give. So yes, he wants to make a deal on DACA, 100%.
Yeah. Well, just sort of, Yeah, I think it's not crazy to say that. Yeah. So Sunny just had some more related questions with regards to her husband and the changing of employer in EB1A.
Well,
fundamentally, I would suspect that there was an attorney that helped her and his husband with that process, and that's I'd say first place to start is those guys would happy. I mean, if one of my clients asks me, of course.
But obviously, yeah. If there's a little bit of a conflict of interest.
Yeah.
Because if the attorney that did the EB1 is the company attorney,
so that's a very good point.
You want to talk about change of employer with.
That's a very good point.
So it's not something that you can discuss. Because you put the attorney immediately in a conflict of interest situation. So you cannot tell them the company attorney, "I'm thinking about changing jobs." Yeah. So now,
was it done with the company attorney? That's you're adding in a presumption, Sam.
Yeah, I am assuming.
Yeah,
I'm assuming. Yeah. But it's good to assume that in advice.
Yeah, that's a good point.
Yeah. You can always hire another attorney to look at your specifics in the case and advise you. Yeah. But I think we've given Sunny the general answer. Yeah.
Okay. So from Hari Guru.
All 4 of us filed I-45 on 9/2021, EAD advanced parole, valid 7/2029, final action date 8/2013, India, wife and kids. H4 is expiring on 12/14/2024. Plan not to submit H4 extension as wife started using green card EAD. Okay? Is it a cause status violation? No, I mean, the H4 extension should not be filed because she's no longer she's no longer in status, but it's not a status of violation because the word violation
it has a negative connotation in it. But
not negative connotation. It implies that there is a breaking of a rule.
Yeah.
You're not breaking a rule. It's a status. She is. Because she cannot extend it because she's no longer in status.
Yes.
But not violation.
Her green card EAD is rightfully issued by the U.S. government because she has a pending I-485. It's just incompatible with her H-4 status. If she wants to maintain her H-4 status, she would have had to have gotten an H-4 EAD that says she's allowed to work as an H-4 dependent. Yeah. Whereas this is a different EAD. She's working outside of the scope of her H-4 status. She leaves behind her H-4 status.
Think about it. She was on one train with rails that are 3 feet apart.
Yeah.
Now she jumped on a train that's 3.5 feet apart. These trains cannot be on the same track.
See, Sam, I like to really carry this metaphor out, the rail metaphor. And she was previously riding 2 trains. She had 1 foot on the H-4 train, other foot on the I-45 train. And
she did the EAD, she changed train.
Oh, yes, she did when she changed. As soon as she took out the EAD, she took her foot off the H-4 train. I just imagine somebody going down with two train tracks. It's a very fun visual.
Yeah. You cannot connect those trains because they're different.
They're different things.
Different
permanent
tracks.
Integration and temporary non-immigrant. Yeah. So I already covered that one. Somebody has said we had no audio, but I don't see anybody else asking that. So I'm not too worried about mentioning that at all. So I'm not too worried about that. We usually figure it out pretty quickly if our
Well, we
audio is-
get a lot of people here
Yeah,
attending.
exactly.
Just
I'm
looking
not
at-
seeing any commentary about.
nobody's upset.
Yeah.
Okay.
Yeah.
All right. So with that, Brian, do you have any more questions
Oh yeah,
for
we
us?
have plenty more questions here. We have time as well.
All
So,
right, awesome.
From
Yeah, you're right.
Akash, going by the current place, will EB2 final action date? Will EB2/EB3 final action date? Will it reach data filing?
Well, the goal is I mean, that's basically the projection. One is the projection, and the other one is the actual. It's the best way
When
to
our visa is available?
describe it.
Yeah.
So the assumption is, but we don't know and they don't know either because they have no idea what's in the pipeline coming or not coming.
So I guess the short answer is what we hope is, Akash, is that the final action dates are here, the dates are filing are here, and over the course of the year, the way we think one way it might work is by the end of the year they'll come together, right?
Yeah. The question is yes based on their projection, not our projection. We don't know because they have the cases.
The data could change, yeah.
They have the cases.
Yeah.
Well, the data cannot change too much.
Well, we figured out there's I don't know.
We figured that's going to be 2.5 green cards per application, 2.5 children, wife and 1.5 kid. We found it was 2.9.
Yeah.
So there were more children that had needed the green card, and therefore we could not get to that date, or we found out there's less children, or we found out that people left the country.
Yeah,
So when
we thought the cases were there. We just didn't get the cases. We moved the dates. We didn't get the cases. So I guess we can move further than we thought.
Yeah. So those are the things it is not something that anybody can predict.
Yeah. Yeah. So check out this one from Mithun. A little bit vague here, but we'll try to give an answer. Would there be any impact on the naturalization process from us getting U.S. citizenship? I guess talking about change in administration in general is how I'm going to choose to answer this. Do you?
Okay. Is there going to be impact? Yes, there will be an impact.
He sure is interested in citizenship. A very big headline was birthright citizenship. I'm very interested in that.
So he is really unhappy about people coming here and delivering children in this country, and then 18 years later, this kid comes here as a U.S. citizen.
Yeah.
Not happy about that.
Yeah.
Birthright citizenship is a unique to the U.S.
It's not entirely unique, but it's pretty darned rare.
Yeah, and it's something that he wants to change that. Now, I don't think that's what you're talking about.
Oh, really?
Here, I mean, he's talking about.
He's talking about naturalization. Yeah.
But it's a conversation about if your child born here in this country on a green card holder, if he changed that to birthright citizenship, now these children get green cards.
Well, yeah, I mean, that's.
And then they have to wait until 5 years until the parents become citizen for the children to become.
I don't know what they're gonna do, but it's what.
He have every intention of doing an administrative and then filing it in court.
Well, yeah, I mean, I looked into this because, I know, Sam, we're very familiar with the clause. This is a constitutional thing. It's in the 14th Amendment, I think it is, or right? And it basically says, people born in the United States subject to the jurisdiction of the United States are citizens, right?
And the exception is there, right?
The exception, what it says subject to the jurisdiction, and what's the big exception that we know about? It's diplomats. Children of diplomats don't become born in the United States, don't become citizens. They become permanent residents from.
Yeah, and then there's some crazy. We've came across some crazy cases.
Yeah.
In our lifetime dealing with that.
Yeah.
But yeah, so.
Basically, the way we've totally. So Sam, that's answering Mithun's question. Are they going to be putting more scrutiny on naturalization? I think potentially.
It's a big deal.
Yes.
Oh, it's a big deal.
Yeah.
There will be more scrutiny. If you recall, the naturalization test became a lot more difficult.
Oh yeah,
during the Trump administration.
Yeah.
And Biden reverted it back to the old one. Now he's going to move it back to the more difficult question. But none of our clients or the people listening to us are going to have a problem. It's just you have to study a little bit harder for it. It's not a big deal.
Anybody in our audience who's interested enough to watch Sam and I, talk about immigration, their level of sophistication, I wouldn't really worry about there.
Yeah. So I think, it will be more difficult, but I don't think it's going to be a bar that you cannot overcome Mithun, honestly, in my opinion.
Maybe take at 7 o'clock. Maybe take one more here,
Sure.
Sam.
Yeah, why not?
Oh, we already took one from. It's a good question. A good question though. It's a good general information. From MG. As part of my L1 extension, my dependents received a paper I-94, which is not reflected on the CBP site. Trust the paper I-94 overrides the CBP records on the site and remains the single source of truth. So the answer is that the last action rule, Sam, do I really want to talk about that?
CBP only when you cross the border.
Correct. So I guess the short answer is this person entered the United States, CBP gave them I-94, appears on the website. USCIS, after they enter the United States, issued them an I-94, and that one controls.
It will never be on the CBP unless you cross the border. So the CBP is your admission record.
Yeah.
Is your physical admission record.
Yeah.
Not admission record. It's your physical crossing the border record.
Yeah.
After you come to the United States, you could change your status to extend it, change it, flip it back.
New paper I-94 on the bottom.
F1, B visa, H1, L visa.
Very impressive. You know all the visas, all the visas. But
And
you get
might as well get an O visa as you, while you're at it.
But
none of that will show up on your CBP.
Paper I-94 from USCIS, that controls. But I gotta warn everybody though, it's that the paper I-94 you get is not always a single source of truth, because as soon as you take that one and you leave the country and come back in again, Customs gives you a new I-94, and the general consensus is well, it's the last I-94 you got is the one that controls.
And they issued at the border.
Which means even if you have an I-94 from your last time you were here that says you're good through 2027, and you leave and come back, check your I-94, because if you have a passport that expires before then, they might shorten your I-94 to, let's say, align with the date of your passport.
100%.
And the results on that can vary depending upon the country you're with, because there are treaties that govern passport validities and how long they can allow you to stay in the United States. A big one is India. By treaty, they consider your passport valid 6 months past its expiration, meaning they can give you entry up until the date of your passport expiration.
And some countries has automatic extension of passport.
Yeah.
It's subject to a treaty, like you said, right?
Yes.
India
And
India is one of the countries.
Yeah.
With that, we end today's session. Until 6 o'clock next Monday, you guys have a fantastic rest.